On behalf of Express Legal Forms, LLC, I would like to discuss transfer on death deeds. This is a relatively new concept. In some states, it is not authorized in all states. We have prepared a PowerPoint presentation which will explain what a transfer on death deed is. Maybe we should just proceed to the presentation.
This is the PowerPoint presentation of the general information regarding transfer on death deeds. Many states allow transfer on death deeds. If your property is located in any of the following states, you may execute a transfer on death deed. What is a transfer on death deed? It's a simple deed with certain requirements. An owner of real property designates a beneficiary to receive the property on his death. The beneficiary takes the ownership of the property upon the death of the present owner. He becomes the owner without probate. It is also abbreviated TOD or TODD. You avoid probate costs and time. The transfer on death deed avoids the cost of probating your real property on your death. This saves time and the normal delay for your beneficiary to receive the real property. The transfer takes effect on your death. Pros and cons of transfer on death deeds. A transfer on death deed solves many of the drawbacks associated with the other mechanisms available for transferring real property at death. Making a transfer on death deed an option will help property owners in a variety of circumstances. Pros and cons continue. It avoids even the small estate hassles of most states. For example, in California, a small estate procedure has a $100,000 limit. This is avoided by a transfer on death deed. Although many states have a small estate transfer procedure to avoid full probate proceedings, the dollar limit of such small estate proceedings varies widely. In Alabama, for example, a small estate proceedings is limited to estates of less than $3,000, and the statute cannot be used for real property. Transfer on death deed option also may protect owners from unscrupulous relatives. Older people often are persuaded to transfer their homes to their children, who then threaten to evict them so they can sell the property. This is especially effective for an individual whose only substantial asset is the home in which he or she lives. Other pros and cons. In contrast with the transfer of property under a revocable trust or will, the transfer of property through a transfer on death deed is much less expensive. In all states, the cost of probate is substantial, and a probate proceeding will cost more than the small fees associated with a transfer on death deed. In contrast with the transfer of property under a revocable trust or a will, the transfer of property through a transfer on death deed is much less expensive. In some states, the cost of probate is substantial, and in any state, a probate proceedings will cost more than the fees associated with a deed. Terminology. Beneficiary, the person that receives the property under a transfer on death deed. A designated beneficiary is the same. It's a person designated to receive the property. A person is an individual, corporation, trust, joint venture, LLC, or public corporation. Any of those can be the beneficiary. A transfer on death deed has to be an individual. How does it work? The property owner executes this transfer on death deed. The deed names a beneficiary, the person who you want to get the property. On your death, the beneficiary obtains the title to the property without going through probate. In contrast with using joint tenancy or legal remainder interest, a transfer on death deed creates no present interest in the named beneficiary. This provides several benefits. The owner does not make a completed gift for gift tax purposes. If the owner changes his mind about the beneficiary, the owner can change the designation at any time before death. Because the beneficiary has no interest in the property until the owner dies, the beneficiary's creditors cannot reach the property. Benefits of the deeds. The deed is not effective until the death of the owner. You retain full ownership and control of the property while you are alive. You can revoke the deed if you desire at any time. Further benefits. You pay the taxes on it. You can sell it, give it away, or mortgage it. It is not protected from your creditors. What happens at your death? At your death, ownership passes immediately and automatically to the beneficiary you named in the deed. No probate proceedings are required. Further, any mortgage or debt attached to the land goes along with it. There is some paperwork to get the property into the name of the new owner. The new owner will need to record a copy of the death certificate. What requirements are there for a valid deed? The deed must satisfy the state requirements for a transfer and death deed. You must put the legal description in the deed. You must sign the deed. If your state requires the deed to be notarized or witnessed, this must be done. It must be recorded before your death. It must be recorded in the county where the property, or at least part of the property, is located. Who may be a transferor or grantor? An individual may be a transferor. A corporation, business trust, estate, trust, partnership, limited partnership, LLC, or joint venture, etc., may not be a transferor. Multiple individuals may be transferors on the same deed. All joint tenants, both spouses of community property, even different estate owners, such as a life and future estate together. What is not required? Notice, delivery, or acceptance by the designated beneficiary during transferor's life. In other words, you do not have to tell who you propose to give the property to. That allows you to change your mind later on. Consideration from the designated beneficiary. In other words, who you want to give the property to doesn't give you any monetary value for it. Can you use a transfer and death deed for real property in other states? Transfer and death deed law is only effective for real property located in states which authorize it. You should use a deed specific to the state where the property is located. Does the beneficiary have any control or rights over your real property during your life? The transfer and death deed is not effective until you die. That means the beneficiary you name in the transfer and death deed cannot control your property. You do not need the beneficiary's permission to sell or mortgage the land. You are not subject to the beneficiary's debts. Does the beneficiary have any control or rights over your real property during your life? Your interest in the real property goes to the beneficiary only after you die. This is the difference between the transfer and death deed and a joint tenancy where you transfer real property to a co-owner during your lifetime. Can the beneficiary be a charity or other legal entity? A beneficiary can be a person or an entity such as a charity or foundation. Does a beneficiary take the property subject to liens and mortgages? The interest transferred to a grantee beneficiary under a transfer and death deed is transferred subject to all mortgages, liens, taxes, judgments, assignments, and other encumbrances. These include claims by a grantor's owner's surviving spouse, or by the state or county for medical assistant benefits if the assets of the deceased owner's estates are insufficient to pay the amount of such claim. This would include a marriage disagreement, a marriage dissolution settlement or order. Can a transfer and death deed be revoked? Benefit of the transfer and death deed is that you may revoke or cancel it at any time. As needs change, an individual may want to revoke the previously recorded transfer and death deed. A transfer and death deed cannot be revoked by your will. However, if you want a revocation, a transfer and death deed may be revoked by the transferor by a later recorded transfer and death deed expressly revoking or inconsistent with with the earlier transfer and death deed. Written recorded revocation, a later recorded inter vivos conveyance. In other words, if you sold the property, that would be the end of the previous transfer and death deed. Must expressly revoke the prior transfer and death deed. Must be acknowledged after the transfer and death deed and recorded before the grantor's death in the county where the property is located. Previously stated, it may not be revoked by a will or by act. Upon the death of one spouse or partner, the survivor may revoke. Which takes precedent, a will or a transfer and death deed? If your will and transfer and death deed are inconsistent, the transfer and death deed controls who owns your real property after your death. A similar rule applies to pay on death bank accounts and transfer and death stock. How do you prepare a transfer and death deed? If you desire to prepare a transfer and death deed, then go to www.expresslegalforms.com and open the video section for transfer and death deeds. There's another video which explains what is needed and allows you to safely and securely enter information directly on the screen. This information will allow Express Legal Forms to produce all the documents necessary. Thank you for watching. Brought to you by Express Legal Forms, LLC.